So I want to start with a tale of two research questions in a lecture today on multimethodism. Let's take this research question. Does putting social rights in a constitution improve social outcomes, social spending? Okay, it might be one of the most important reasons we put social rights in the Constitution. We actually want to make a difference in social welfare and people's social participation. In a recent article by Adam Chilton and Miller Versteeg, they asked the question quantitatively. If we've seen the introduction of all of these social rights in different constitutions across the world, education, health, housing, social security, does that make a difference for people's social rights? And in particular, does it change government behaviour? Okay? Their line of reasoning is, well, duties in constitutions most attached to governance. If we put social rights in, then we presume governments would change their behaviour, and one of the most important ways to change the behaviour is to change social spending and then ultimately improve social rights. There's an existing literature of around 5 or 6 studies where people have tried this on other social rights with some mixed results. On the right to social security, some positive results. Other results show if you put social rights in the Constitution, you might go negatively in terms of outcomes. The most positive research seems to be on more collective rights, rights to have political parties, and trade union rights. These seem to have positive correlations. But they come along with perhaps better data, more sophisticated methods, and they run a whole lot of models, but their basic model is to start with a dependent variable, social spending, or social outcomes, and see whether putting a constitutional right, a social right in the Constitution makes a difference. And they control it for a whole lot of features of the country, whether it's the economy, GDP, inflation, demographics, like urban population, the age of a population, whether there's a war going on. And what do they find? Pretty much no correlation. So putting the social right in the Constitution doesn't improve social spending. It does seem to correlate with some outcomes, I think it's like child mortality, but overall their message is this. While constitutionalising social rights has generally been met with great enthusiasm in both academic and policy circles, we find that doing so does not appear to shift government behaviour. And that line, that conclusion, you find in the introduction and pretty much through most of the article. What strikes me about this conclusion is how strong it is. Because the only condition here for their finding is the strength of their evidence, okay? Does not appear. One can level some critiques against this sort of research design. For the first, there's no theorising about why social rights are put in the Constitution, okay? They take an aspirational theory that we put social rights in the Constitution to improve social outcomes and social budgets. But what if social rights were put in the Constitution to preserve existing social welfare arrangements? Okay, and in that case, we shouldn't expect any major change, and rights basically stop regression. And we see that mostly social rights are mobilised in practice to protect rather than often to advance. The second thing is that the causal theory is deeply influenced by a quantitative logic. The change is linear, okay? That if we you drop a stone in the water, you expect ripple effects, okay? You throw something in the mix, some social rights, shake it a bit, and the chances of increasing social spending or outcomes increases. But there's another sort of logic. We can call it qualitative logic, but an if-then logic. Okay, if we put social rights in the Constitution and then we have the following conditions, then we may get a positive outcome. Okay, so constitutionalisation may be a necessary condition, but we might need some other sufficient conditions. This is precisely the point that Johan Jakobsen made on Monday with the chess analogy, okay? You don't win a game of chess with your first move, okay? You move the pawn or you move the bishop. There's a whole lot of moves you have to make and anticipation of counter moves before you can take down the king of the other side. So qualitative logic tends to look at these other conditions. Now, quantitative people do this. They often introduce interaction terms in their regressions to say, well, what if there's a constitutionalization of social rights plus this other factor? And other factors they could have looked at was, for example, level of democracy, or is there judicial review, or the strength of institutions? What can we learn? What sort of conditions are needed in order for constitutionalization of social rights to have effect? They discuss some theories that shows the limitations in this direction, but don't actually measure it. And then they do a partial review of the qualitative literature, but they don't discuss the qualitative studies showing the opposite result. Okay, so they cite Dan Brink's and Warren Guy's work, which involves 5 countries, which is mostly qualitative in orientation, which shows a mixture of results, and under certain conditions, constitutionalization of social rights may work, but it's actually not discussed. What struck me was also this sentence. As another prominent example, South African scholars have observed that the famous Groupboom decision was never fully implemented. Indeed, 8 years after the landmark ruling of Groupboom, Irene Groupboom passed away penniless and without a home. This doesn't even get a reference, but in some ways they didn't need to put a reference because it comes from a very famous article published by the Mail and Guardian in 2008. Interesting, this one newspaper article has more citations in Google Scholar than the average academic article. And if you do a Google search just for Groupboom died without a home, you get around 2,000 results. I'm still going through this to show the way in which this particular newspaper article has diffused throughout the world and is commonly cited, with references or not, as to what happened in the Groupboom case. So what was the Groupboom case about? It is the most famous socio-economic rights case. Basically, the reasoning in the judgment is the same as the New Jersey Supreme Court in 1973, but this South African case garnered wide attention. South Africa has been central in discussions around constitutional rights. They put the right to housing in their constitution in 1994. In 1999-2000, a group of slum dwellers who had been evicted twice end up on the edge of a sports field facing threatened eviction again. They go to court on the basis of the right to housing and argue they have the right to stay and get at least access to basic services and maybe some sort of housing for children. They win the case in the end. They get an interim settlement order on some basic materials, and the court makes a judgment that the national, regional and local authorities have to have a national emergency housing policy for groups in emergency situations on the basis that a right to housing means you have to have a reasonable program of action with reasonable resources, reasonable plans, and so forth. So the Groupboom judgment becomes the poster child of the socioeconomic rights movement. And then it also becomes the poster child of no effect, of no impact, okay? And it's this article that is particularly used to show, look, this famous case, but the lead applicant, Irene Groupboom, a phenomenal woman, she dies 8 years later without ever getting a home. What's the use of going to court? So first question, did she actually get a home or not, despite this? Well, yes. I visited it in May. They actually built her house, and here you can see the construction company. They even made a special extra banner for the house they built for her. The houses for the Groupboom community actually look like this, okay? And the house they built for Mrs. Groupboom is you can just see the edge of it there. So what happened? Well, it turns out that all the researchers who've been citing that never actually visited the community. And so what I did in 2002 is actually visit the community recently, just after the judgment, and found out what had happened, and saw that they in fact got the aluminium sheets, which were part of the interim order. They got the window frames, they got some roofing materials, and they got effective protection from forced eviction. Okay, that was the first thing. Then I had research assistants go there in 2012 and find out, did they get housing or not? It turns out that firstly, the municipality misinterpreted the order. The order was just for a national emergency housing policy. It wasn't actually to give the group housing. But the municipality thought they had to provide housing. Okay? So law works in mysterious ways, okay? Okay, there's law in the books and there's law in action. Okay, there's two worlds. Secondly, they did a survey of the community and found out there were 4 other communities in worse situations. So they started developing what's called matchbox housing there, 25 metre square homes with electricity and water. By 2007, they get to the group room community. Half the community chooses government-built housing. The other half of the community choose contractor-built housing. Okay? And what was the subject on Monday that we talked about? Corruption. Okay. So those who chose the government building got their houses built by 2008, 2009. Those who chose the contractor model got hit with corruption and their houses were delayed. So Mrs. Groupum's house was under construction actually when she died. That actually comes through in one sentence of the newspaper article, but that's actually not reported. Today, so this is here visiting the community in May, 90% of the community got permanent housing and are extremely happy. And the irony is actually that there are 2 Iodine group room houses. So there's a one back here, and then some entrepreneurial figure thinking I could raise funds for a new NGO if I have a group room centre here has also created a second Iodine group room house. So that's all part of a book we did on socioeconomic rights in South Africa, which involves a number of people in the centre and elsewhere, looking at when do courts and constitutionalisation actually have an effect and when do they not. And in the chapter in that book, I look at the different effects of the group room judgment. The material impacts, both for the community, the systemic effects, for example, on jurisprudence and social policy, but also political and symbolic effects. Did it help the community mobilise better or not? Did it change public opinion on slum dwellers? But the important point was that, in fact, the 2 major things that are complained about in relation to the impact of the judgment actually happened in practice. But this is just a single case study, and so I also did a comparative case study and found 7 other cases that began in exactly the same situation, where a slum community was affected by forced eviction, they went to court, what happened? And I had a whole lot of impact variables, whether they were evicted, whether they got housing, whether they got services, whether their political organisation was improved, whether it led to a policy change or a legal precedent. And what I found is variation. Okay, in some cases, amazing effects. Okay, in the model clip case, 100%, they got all of this. In other cases, pretty much nothing. And so it's a different way of seeing what's going on. Under some conditions, communities are able to use constitutional rights and courts to great effect, and others not. So, all's good. Qualitative research, go to the field, get the context. But, so yes, sometimes context is really, really important. I've given you some examples here. Perhaps the most dramatic example is the assassination clause in the Afghanistan constitution. Okay, so what's that about? In the Afghanistan constitution, you have basically a preferential-based system of voting. You get 5 candidates in your constituency. If one of them dies, then the candidate that was number 6 becomes the representative. Now, in a Western democracy with high levels of security, you would expect that system might work. Okay, we have it with the US presidential system. Okay, if Donald Trump dies, Mike Pence becomes the president. Okay, do we expect Mike Pence to try and ensure that Donald Trump is assassinated? No, we don't even think about that. But in Afghanistan, they do. Okay? So if candidate number 5 dies, okay, suddenly it's a mine or it's a shot in the night, then candidate number 6 suddenly comes into position. So you can generalize, okay? You can say, in most countries, this system, okay, of an automatic replacement, you avoid having to go to a by-election, for example, okay? Your candidate is there. We have it in Norway in relation to many positions. It will work, but in this context, it's led to the assassination of multiple politicians, okay, so that others can take their place. So we have to be careful with generalizing, okay, and just a sort of quantitative logic. At the same time, as Tom Ginsberg says in relation to, say, comparative constitutional law, it can often be the best we have in trying to think generally about a particular area. Yes, the data may be weak, okay, causal, different variance is difficult to explain, but it may be all we have. And I've also done studies that show this sort of, these results, and this is what I want to come to next. So let's take another story from a completely different field, international investment arbitration. So what is this all about? We don't talk about this area so much at Bergen Exchanges, so I thought I'd introduce a new area of law. So some of you may have heard of the Cochabamba water wars, okay? Between December 1999 and April 2000, Bolivia was beset by protests on water prices. What had happened is that the water system had been privatized. The company was obligated to expand services, particularly also build waste management plants and so forth. One solution was to increase the price of water, which increased by a factor of 3 in some areas of the city. This led to massive protests, and the multinational investor, Aguas de Atenare, which was in a joint venture with a US company, Bechtel, leaving the country. What was the result? What did Bechtel do? Well, they took a case against Bolivia. Okay? The Netherlands had signed a bilateral investment treaty with Bolivia, which said that if you expropriate the property of a foreign investor or do not treat them fairly or equitably, then the investor can seek compensation. As it turns out, like with many multinational companies, they have their headquarters or some of their offices in the Netherlands, because the Netherlands has the most pro-investor bilateral investment treaties, and they sue from the Netherlands the Bolivian government for $25 million US. This leads to further protests and the first attempt at an amicus curiae submission by a range of groups saying this actually threatens the right to water because the prices have increased so much. We saw this across Latin America, particularly in Argentina, where also various protests led to the withdrawal of multinational investment companies when they were, for example, not able to increase prices, whether by government decree or through protest, which led to also these sorts of cases. And it formed soon a legitimacy crisis in international investment arbitration. There's around 3,000 investment treaties, bilateral or trilateral. The most famous one is the NAFTA agreement, okay, which allows investors from Mexico, Canada or US to sue the governments of the other countries for interfering with investors' rights. There's around today 1,300 cases, okay, of investors under these treaties taking cases. The overwhelming majority against developing countries, that includes low income, low middle income and high middle income countries, most against Argentina, Venezuela, but also Ecuador, but also countries like Spain, okay, in relation to solar energy, the debacle that happened there. But people began to become concerned. Another case that got a lot of attention was against South Africa, where investors challenged affirmative action provisions, saying, we can't have historical disadvantaged South Africans in our corporate structure, management, shareholding, that we wouldn't be able to operate. And therefore they challenged affirmative action provisions in South African law. So the concern was that this whole system was pro-investor, okay, because investors had no obligations, but they were able to take these cases, that it was pro-Western states rather than developing countries. Most of the developing countries were not only the respondents, but they often lost the cases more often, at least from what we could see. But also that the system was largely non-transparent and it was not clear who was controlling it. The existing research on this was mostly qualitative and small n, and largely polarized, okay? So people work with small data sets and bivariate analysis. So Susan Frank in 2007 found, yes, if we just look at the raw data, developing countries lose more often than developed countries, but It's not statistically significant, and then it may be explained by levels of democracies in these countries. Because they have lower levels of democracy, they're more likely to interfere with investor rights, and we can explain it away that way. But we're talking here about a data set of around 100 cases. It's also cherry picking of cases by both sides. Okay, so there's a claim by the NGOs and activists that this is terrible for human rights and the environment, but they'll choose, say, like the Cochabamba case, and then the other side will choose some other case where investors were fighting for freedom of expression in Russia. Okay, and so it's media companies, fighting against Russia to maintain free expression in the country. There's a number of interviews and anecdotes that were quite common, and some of it's interesting material, but there's a danger of people just saying what the interviewee wants to hear, and so on. So what we've done in a project is to take a very quantitative approach to try and generalize. What can we actually say? I'm going to go through this very quickly just to give a sense of the different methods we've tried to use to answer this question. Should we be concerned about this system of arbitration? Are the activists right or are the apologists right? We built a database of 1,300 cases. We coded it for around 150 different variables in those cases. And we're increasingly also putting all the text of the decisions in so we can also do computational analysis. So, for example, one study we did was responding to Susan Frank's work. Do developing countries lose more often than developed countries? Well, on the raw data, when you start to look at 350 cases, yes. But secondly, we took her argument seriously, but we said we have to look at other factors than democracy. Let's look at different democratic governance indicators. Perhaps the lack of rule of law in Venezuela or Malawi explains why it's quite right that investors perhaps should win these cases. But even when we control for all of that, except for one indicator, we see that high-income countries are still likely to win much more often than the developing countries. So if you're an investor taking a case against a Western country, a developed country, you've only got a 20% chance of success. But that rises to 40, 50, 60% if you take it against a developing country in the lower income quintiles. So it starts to suggest that maybe there is a problem. But the problem with our study was we didn't know why. Okay. Are the arbitrators biased against developing countries? Is there a structural problem where the legal representation from the developing countries is poor? And that explains it. So another interesting study that came out just after this by a scholar at Princeton shows that perhaps one of the problem is actually the strategy of developing countries, that they settle too early. And they seem to, just using a quantitative analysis, settle on good cases that they might have otherwise won. So and this is classic for quantitative methods, we're still finding our way forward to a causal explanation. We will also try and do an experiment on this to see if it could be attitudinal bias. Another claim was, well, the system's getting better. Okay, so yes, it was very pro-investor at the beginning, but all these doctrinal scholars show, look, they're becoming more deferential to states, they're introducing proportionality doctrines, okay? Saying they're balancing sort of states' concerns about regulation with investors' rights to freely operate in the market. So we did a regression analysis examining trends over time, trying to control it for different factors, and do we see a relationship between state backlash and investors losing more often, okay? So we have a number of measures of backlash, okay, from numbers of treaties, the drop in treaties being signed, treaty exits, discussions on the problems of the system. And we find that, yes, over time, the system seems to be partly reflexive, okay? We find some correlation between the backlash and the crisis and arbitrators being a little bit more cautious, okay, and a little bit more pro-state. But when we compare it to what happened in the WTO, the trade system, it's much less. There you see a much stronger relation. When the US and the EU particularly are very unhappy with the WTO, they begin to back off. And we don't see that necessarily in investment arbitration. We also did some medium end analysis where we went and looked at all the environmental cases, okay, to avoid cherry picking, which we saw both sides doing. There's around 50 cases. We use the various statistics to get some metadata on these cases. For example, what were the potential types of environmental cases that were going on? They were very different. They varied from general environmental legislation to a lack of environmental permits at the local level. And one of the interesting things about this work is I've worked with somebody who has a different normative view than me. So I'm a bit skeptical to this system, and my colleague is a bit more in favour. So every time we do one of these studies, we never know who's going to be right, okay? So the first two I was kind of right, and this one I was thinking that, you know, it was investment arbitration is really bad for the environment. But we found all these, you know, counterintuitive cases where it made it difficult to be as critical. And so we come up with a more nuanced story there. There's also been experiments in this field, for example, one by Sergio Puig and one by Anton Streznev, looking at affiliation bias. Because one of the interesting things about arbitration is you are appointed, or two of the three arbitrators are appointed by the parties. So the claimant appoints their arbitrator, the respondent state appoints their arbitrator, and then there is some system to appoint the third party, whether the two arbitrators agree on it, or it's appointed by a body under the World Bank ICSID. And they find out with experimental study where they sent out a case of 200 to 269 people, short case, and say, who would you judge for? And they tell basically a bunch of arbitrators and law professors which side appointed them. Okay, you have been appointed by the respondent state, Argentina. You have been appointed by Coca-Cola. It turns out it matters. Okay? And this is one of the concerns with the system, as that it's driven by party partiality rather than sort of impartial approach. Another critique of the system is of double hatting. That there are lots of arbitrators who are simultaneously acting as advocates in other cases. Okay? So I can be sitting as the arbitrator in the case between Bechtel and Bolivia, while I'm an advocate, okay, in a case between Bechtel and Argentina. This could never happen in a domestic law system, but happens all the time in investment arbitration, according to some. And it also was a source of prestige, okay? Particularly if you're a law professor and you're just like, you know, I'm arbitrating these 20 cases and I'm acting as counsel in these 15 cases. It certainly increases your symbolic capital in both the academic and arbitration market. But there's concerns about conflicts of interest, okay? You're an advocate in one case, you fight. So it'd be helpful to have a precedent that helps you when you're an arbitrator in another case. But nobody knew how often this was happening. And the general discourse in the community was, well, it's decreasing over time. So we went out and measured it. And we found that in 47% of cases, there was an arbitrator and advocate who had the other role in another case. And this is not the full data for 2016, but you can see it's also been increasing over time. We then did something, and we're going to talk about ethics today, which was right on the edge. We published names. We published the names of the top 25 and then later the top 10 double hatters. And if you're in international law, you will see names that are not just any names. Like, these are some of the biggest names in international law. Paulson, Crawford, Schwebel, and so forth. We became very popular with some people and very unpopular with others. Last October, we received an email threatening us with a lawsuit in the United Kingdom, or in England, for damage to reputation. So we spent 6 months, we had to get a lawyer involved in trying to negotiate with this arbitrator, who meant, interestingly, that our method was wrong, okay? That the cases that we had selected here with Vault shouldn't have been in our case selection. The way we measured the beginning of the double hatting, okay, had happened too early or too late. So it was an interesting pages and pages of academic debate about a method that could lead to a court case. We don't think it's going to happen now. We haven't named the person. I'm not going to tell you. You have to, but if you take me out for a drink, maybe no. But It had a remarkable effect. Okay, the Twitter went absolutely viral. We know that there's discussions on various arbitration panels, and we're about to measure again to see actually whether this research, but also some research by a civil society group on the ICJ, which has a similar problem, has actually changed practice. But we can talk later about the ethics of naming names and the challenges that come with it. But in this case, we felt these are powerful people, like judges, and this could have an important public policy contribution. We also, as part of that research, did networked science, because one of the concerns is that a small group was controlling investment arbitration, which made the system less legitimate, particularly for developing countries. It was commonly referred to as male, pale, and stale. Okay, older European and American men judging these cases. There was an initial study by 2014 in Sergio Puig. We then expanded that to weight the roles of the different arbitrators, but also include legal counsel and expert witnesses in the mix to see who was really running the system. And basically what we find is what you find in all network science, a 10 to 90 or a 5 to 95 relationship, okay? That this small group, 25 arbitrators, take 50% of the cases, and they sit in all the most important roles. And so that also revealed there was potentially a problem. We also studied the gender, and we're going to talk about gender and judging later today with an interview. Okay, only 11% of cases women arbitrators. And this has also been an issue for the legitimacy of the system. We then calculated how long it would take to get gender parity. And on current trends, and sometime in the year 10,043, we will get gender parity. And why is that? And then we, drawing on the American literature but going further, we basically find a structural problem. It can partly be discrimination, but there's a problem in that the recruiting to this system is limited. Every year, only around 5% of the new arbitrators are new. They've never had a case before. So the system is dominated by the old. So even if you increase to 50% or 100%, the number of women amongst those new arbitrators, you will take years to get to any form of gender parity. And we can see the types of measures here. So that also indicated there was a problem. We also looked at developing country nationals as arbitrators. We found that they weren't really increasing in number as everybody thought they were. And they pretty much only get appointed when someone like the World Bank actually ensures their appointment. Parties are almost never likely, even developing countries, to appoint developing country arbitrators. But then we try to ask, does it matter? Does it matter if you have a developing country arbitrating side? Will they be more likely to rule for a developing country? We ran the regression just recently, and maybe a little bit in that case. So it could help. Finally, we've also begun to work with machine learning. Another critique is that these 25 arbitrators running all these cases aren't actually writing the decisions. Okay? And that's been a critique of also the US Supreme Court, that the clerks are basically writing the decision, which raises issues around legitimacy. Are the judges turning their minds to the cases? But the challenge, and there's a whole lot of interesting research on the textual patterns in the US Supreme Court, where they've found for some judges, they're often letting their clerks write the decision, but for other judges, they write their own decisions, like Scalia, okay? It's quite famous, and it's very clear. He has consistent style across all his judgments, whereas others don't. The challenge for us was that there are 3 arbitrators in every panel. One of them is paid 80% of the time, for 80% of their time, and then you have these 2 wing arbitrators who do less. Then you can have assistants on the side and tribunal secretaries. So we have an interesting project trying to work out who actually wrote it. And to do that, we have used machine learning. So we have trained the computer to look at the style of arbitrators' works in their academic work, when they write a procedural order, and so forth. So it's using a Python program, which is looking at everything from how you use quotation marks. What sort of words do you use? Do you use thus or therefore, for example? How do you order your sentences, long and short? How do you have paragraphs? And it looks at all of these combinations, and then it predicts for each decision who the computer thought actually wrote the decision. I haven't put the names up here. And we've gone further with this. What we find is that for some arbitrators, there is consistency in their style, and for others, there is not. So this is a research project we have. There's a number of other researchers that we've worked with, also Wolfgang Elschner, who's done very interesting work on citation networks and so forth. And then we're now seeing a reform process starting up 2 years ago in the UN to reform international investment arbitration on the basis of all the concerns I've talked about. And this is one of these rare moments where you go off and research something just because you're interested in it, and it turns into public policy accidentally. So we turned up a year ago at Vienna. This is another member of the team. And suddenly all the empirical research that we had done and everything we knew from the other scholars, we could feed in. And by the end, we were asked by the states to actually lead off sessions with the empirical research, for example, on double hatting, because we had it. It doesn't mean all of our research is right. It can be critiqued. And I'll talk about some of the weaknesses in my own research, not just the successes as we go on. So a quantitative perspective may help. And that's one of the reasons we found in presenting the research here is all the other actors were very much had small data sets, anecdotes, which were not so convincing for states. So there are two types of ways of thinking about the way we go forward in research. One of them is method-driven. We often like to make fun of people who are method-driven, okay? Those quant people, okay? They throw a regression at everything they find, okay? Or they have to code everything they see. But I would say that most of us are method-driven, okay? We find a problem, and we use the tools that we know, okay? So lawyers, okay, have one method, okay? The doctrinal method, okay? Give me some text that I will interpret, and I will tell you what the answer is. And if you force me in one of these, law transform projects where I have to do an impact analysis, I will go see, has there been an increase in the number of judgments on this issue, okay? I'll track the volume of litigation in this area, but don't push me any further. And law is fascinating in basically an entire discipline being driven by one method. But they're not alone, okay? So anthropologists, okay, also, like the lawyers, love the case study, okay? It's all about the case. So when I got my PhD grant, and which was partly on comparative work, I had an anthropology colleague ask me, the first thing he asked me was, where are you going to do your field work? And I was like, wow. I thought to analyse, do a medium-end study of 28 countries, do some quantitative work, but it's just presumed that, of course, I would be going to, Egypt and then South Africa, and for 2 years of my thesis. Other disciplines tend to have a mix. The rest of the social sciences, psychology, political science, and sociology often have a mix of quality and quantitative. Economics is dominated by quant, but has some qualitative. We've also seen the rise of experiments, particularly coming out of medicine and psychology, coming into political science, and now economics and sociology being increasingly used. We're going to talk more about that today. We've also seen the movement of network analysis from mathematics and physics into sociology in the 1930s, and an explosion of network analysis in the last 10 years. But again, you also get people who just do network analysis, okay? So, I have to find my ties and, my nodes and my ties, for everything, every problem that I'll look at. And then we have the rise of computational methods, quantitative text analysis, machine learning, agent-based modeling in that respect. But before I trash method-driven approaches, let's think about the advantages. Firstly, you're often linked to a disciplinary body of theory. And this is, that guides the use of that particular method, okay? You don't just run off and run a regression or, jump into the field. You're informed. Your methods are informed by different theories as to how you should be describing, how you might be explaining. Secondly, there's quality assurance and a community of practice. You've got people around you who are going to critique, okay, your regression model. Ask you questions. Did you use fixed effects or not? Okay, how did you code your data, and so forth. Thirdly, for many methods, there's issues of ethical clearances and practices, and they can vary dramatically by disciplines. So I've been doing increasing a lot of work with experiments. Okay, and in the US, if you're doing an experiment in psychology, you can lie. Okay, perfectly fine to lie, and then at the end of the experiment, you say, by the way, that judgment didn't happen, okay? Or that event didn't happen. If you're in economics, you don't lie, okay? If you're doing an experiment in Norway, you can't lie at all, okay? Which makes you have to do a whole lot of follow-up sort of robustness sort of experiments to ensure that you're not in problems. There was a fantastic proposal actually in Berkeley, which almost got through, where every time you lied in an experiment, you had to pay like a tax into a fund for experimental research, okay? So just to sort of disincentivize too much lying, because it has sort of social effects. People remember what the treatment, not what you told them afterwards, that it wasn't true. And then the psychologists vetoed it at the end because they realized that they would be subsidizing the research of the economist. So it never got forward. Also, for many questions, a single method may be enough, okay? That's for the type of, If we want to know whether Article 12 in the European Convention of Human Rights can be interpreted to include same-sex marriage. Okay. Legal methods are mostly going to do the job for us. Maybe we want to think about whether the court would actually do it, okay, major legitimacy, backlash issues that would follow, some social science will help. But if we have a very tight research question, then the method may be enough. But the challenge is we often reach for the hammer, regardless of whether it's a nail or not. And there's certain disadvantages of method-driven research. Often becomes our default model. It's fetishized and reified, and we end up with paradigm wars. Okay? So I've been in multiple workshops where a lawyer, a judge, or a qualitative researcher sees quantitative work on courts for the first time. And there's like this explosion that happens in the back of the room. The heartbeat just, people, shocked that you can reduce the complexity, okay, and nuance of legal text to a number. I mean, it's blasphemous. And so you get these paradigm wars where quantitative methods can tell us nothing, okay, about how law operates. So the first problem. Secondly, that findings get stretched in interpretation. Often our models aren't quite good enough to answer the question we want to answer. But it's so tempting, okay, to draw as much as possible out of it. And that goes back to my critique of the first article, because I think it's actually really important research. My major problem is how it was reported and the impression that it gave. The third thing, and perhaps less talked about, is a method is constitutive of knowledge. The way we study things soon starts to affect how we see the world, okay? So if I study things probabilistically, okay, if I introduce, a stone to the water, A into this context, I start to think about the chances of B, okay? Whereas if I'm a more qualitative researcher, I might start to think about the world in different ways, the different factors that have to combine to get a particular result. Or a legal researcher, I start to think that, yes, if we have this particular interpretation, that's how the world works, okay? So you do 3 or 5 years of law school where you are taught that the world, okay, is what is found in these textbooks, okay? And there's this major shock as law students go out, and the world is completely different. Okay, things are interpreted completely differently, even by the courts that you were studying. But it's very difficult, even for lawyers after years of experience, to move on to a different epistemological way of seeing the world. And it also ignores the movements of methods. Okay. many methods have a very short history in particular disciplines, for example. So network analysis, as I said, has only newly come into different disciplines, but it's already been, reified as like this is the way we do things in some areas. So think about if we just really held on to a particular method in a particular discipline, we would have never have got the guitar from there to there, okay? The guitar, we only use it for this, or maybe there's different ways of using this method in different contexts. So the first thing I want to argue for today is that we also need question-driven research, okay? Where you start with the bracing idea that what is the best method to answer the question I want to ask? And if there's no possible way to do that, then should I ask that question? But can I find a way with different methods to answer the question at hand? So the advantages of this is it might expand our knowledge. We might be able to answer the question better. It might be a descriptive question, okay? So maybe quantitative measures will give us more breadth. Qualitative approaches or legal approaches will give us more depth in describing a particular phenomenon. In terms of explaining something, okay, quantitative and qualitative methods have different advantages, as I will come to, in helping us explain phenomena. But also many social sciences, not all, anthropology, doesn't like to predict or even explain often, but the economists, political scientists, partly psychologists, but also lawyers like to predict. But not all methods are good at predicting. So the classic quantitative regression analysis, which has dominated many of the social sciences, is rarely used to actually predict. We rarely go out and test again, did my coefficients work in T+1? The year after I published my journal article, 10 years later, did what I find actually continue in practice? Economists perhaps have been the best at that. But we have new methods coming like computational methods, machine learning, which are all designed for prediction, okay? That is actually the model. And the model is based on how well it actually predicts rather than the R-squared value or the P value in your regression coefficient looking backwards. But also, lawyers are very good at predicting. Okay, so we've seen an increase, for example, of the use of qualitative and quantitative research in reform process, drafting a new constitutional reform. So Tom Ginsberg has travelled the world and others advising countries on reforming their constitutions, drawing on that research. But as he observes, lawyers are often just as good as predicting the outcomes of a constitution. Now, lawyers are terrible at explanation, okay, because we don't get any training in causal theory. But what a lawyer can do is look at a text and imagine all the dastardly ways you could interpret that text, okay? We are trained to have a pessimistic sociological imagination, okay, as lawyers. Think about the worst possible interpretation of this contract clause or this constitutional provision, okay? And the lawyers, we come up with it, okay? We don't trust human nature. And we can tell you, so maybe that assassination clause wouldn't have happened in Afghanistan if a local lawyer and a comparative lawyer come together. I've got 5 minutes and I've got around half an hour to go. So let's see what will happen. And we can enrich different forms of knowledge, observational knowledge, which I've mostly talked about, but also revelational knowledge, which is often what lawyers do. We try and derive meaning from the actual text and potentially reason. We have many theories, particularly in political philosophy, looking at law that are based on certain assumptions, and those assumptions are never empirically grounded. And it may expand our theoretical repertoire. One of the things I've learned about going into different methods is you actually end up learning different theories. So by doing network analysis, I've appreciated the importance of actually network theory in explaining behaviour. So just a few examples. This table, which I'm going to distribute because I don't have time to go through, gives you the advantages and disadvantages of quantitative methods and qualitative methods and distinguishes in many ways the difference. So I've talked a lot about how qualitative helps you on identifying necessary and sufficient causes. There's a more mathematical logic, whereas quantitative is more correlational probabilities. for example, when you have also a deviant case, something doesn't fit, then you need to go and look at that more closely. Not necessarily the case. In quantitative methods, you try and build in more independent variables to get away your error rather than really engaging with the error. Secondly, we might want to combine different methods because different methods have different strengths in, for example, causal explanation. An experiment is very good in internal validity because it pushes all the other external factors away and say, does this particular factor, okay, telling you which party appointed you, affect your potential decision? But often we don't know for an experiment whether it works in the real world, whether it has external validity, and other methods may be important, may be better at that. I'll have to move through this. Can I have 10 minutes? Is that all right? So I'm getting different opinions from the front row and the back row. I'm getting a thumbs up. Fun? Thumbs up. We started a bit late, so maybe I can... So, what is multimethodism? Firstly, it's not a contextual departure point, okay? Citing a few numbers in the beginning of your qualitative research, and then off you go to do your case study. I mean, almost every article has some statistic in the first paragraph. 60% of people in the world lack access to advanced forms of social security, and then off we go with the study. What it is, it's integrating method in some way. It may be in the research design, so very tightly designed mixed methods approach. It may be a research program where different people are doing different projects, answering the question. Or in trying to synthesize research from different fields to answer a particular question, some sort of systemic review or literature review of the studies. And we're going to talk about that a bit later in our international lawfare project, how we've done that, okay? So we have... for example, Rachel's study, sort of more qualitative anthropological study of the Inter-American Court and Amicus Curiae, in the same book as an experimental study on the impact of courts on public opinion in relation to criminalisation of prostitution. So they're part of the same research program, but we have another paper in that project where in a single paper looking at the effects of the Tuna decision, which is the first international decision finding that criminalisation of same-sex relations is a human rights violation. Okay, we have sort of a median statistical analysis in Australia, looking at 28 decisions. We have a deep, qualitative case study, and then we do a large end study at the international level. And I can talk more about that. How you go forward with mixed methods can be different. There's a journal of mixed methods. There's a whole community of mixed methods that now reifies and fetishizes mixed methods. And there it's very intentional. But you may also find your way forward accidentally as you go along or technically. How? There's different ways of doing it. There's a sequential approach in which you start off with a quantitative theory, and then you do the qualitative work afterwards, or which Beth Simmons does in Mobilising for Human Rights, or Dan Brinks and Veron Garai in Courting Social Justice, start off more qualitative and build up to later quantitative work which came out of that project. Another approach is to go concurrent, try and do both types of different methods in a single research design at the same time. It might be triangulation. Okay, so you have a survey plus focus groups, for example, or it might be nested, okay? A survey may contain both quantitative and qualitative questions. But then what the mixed methods community hasn't quite caught up with is also computational methods, because that fuses text and numbers, okay? It turns text into numbers, but it takes the content of the text seriously. And that enables all sorts of other types of methods, and it's difficult to even categorize. But now we've got papers, for example, predicting the outcome of the European Court of Human Rights decisions based on the text of the facts. And you can predict, according to this study, with around 75% accuracy just by knowing 3 sentences of the facts of the case. To conclude, challenges. 3 main challenges. The first one, and this is the one is only really being taken seriously in the last few years in mixed methods, is incongruous epistemologies. And I hear it every time, okay? You talk about this with, say, a sociology PhD. But that way of thinking about the world, I just cannot engage with. Positivists say, well, we can combine knowledge, okay? When we describe an elephant, everyone has a different description of it. But if we just take off, okay, the blindfold and we talk, we can fit knowledge neatly together and come up with an answer. Constructivists say no, we can't bridge that particular gap. They're just the ways of viewing the world is just too different. How do we resolve this? There's a number of ways. The first is some people have come up with rigorous triangulation, where you try and systematically put quantitative and qualitative work into a similar language, a similar metric. And there's all these techniques, okay, for deciding which method should dominate in your conclusion. There are others who say, well, the qualitative and quantitative methods are not so different. They're really on a spectrum. A third approach is postmodernism, bricolage. It doesn't matter that we can't really fit these things together. We just come up with a story, and then you go sort it out and you interpret it for yourself. We have neo-behavioralism, which says, let's just focus on methods that predict best, okay? And so whether it's in psychology or machine learning, let's move away from trying to explain. If it works, but even if we don't know why, let's go with it, okay? Facebook does this every day with the algorithms. It doesn't know why you like this particular dress, okay, or this particular razor, but on all the data we have, we can predict that you like it. But what I want to argue is that we need a post-positivistic approach. And that's hopefully the way forward, where we suspend judgment. We don't necessarily try and come up with a congruous epistemology, but find ways to think about different types of methods and their results together. And it's often through some sort of heuristic, okay, that we develop over time. And as Tom Ginsberg says, hopefully we'll do no harm. So there are also challenges about skills we can discuss. Can we actually do different skills, which I'm not going to go. Can we learn new skills and how can we get above it? You can see the solutions. And we have ethical issues about whether we can actually, to what extent we can do it in practice. Can we overcome the disciplinary base for many ethical demands? And so to conclude, there's lots of methods out there. It's like a lolly shop. There's lots of potential. If we want to take a question-driven approach and actually answer the key questions, we probably need to go into that lolly shop, that candy shop, and find something. But at the same time, we have to be aware of the drawbacks. When we pick our poison, there's always going to be some drawback. A question-driven approach may not always be the best approach, but I think we need more of it. And we also need to move away on a way forward to think about how we integrate knowledge. And I think it's really important for a centre like ours, where we have so many different researchers. How do we combine Rachel's work with Dan's work, with Siri's work, with Ruth's work? Thank you very much.